Welcome back to A Little Privacy Please. I'm Julie Rubash, General Counsel and Chief Privacy Officer at SourcePoint by Dodomi. This is my weekly series covering what matters most in data privacy. This week, California regulators fined two very different data brokers within days of each other, and Colorado released draft rules that provide more detail around automated decision-making and chatbot obligations coming into effect January 1st. Let's get into it. Within a 3-day span, the California Privacy Protection Agency issued fines against two data brokers, LocateSmarter, an Iowa-based skip tracing and investigative data company, and Cybba, a Boston-based ad tech company. Both were fined for failing to register as data brokers under the Delete Act. LocateSmarter was also found to have violated the CCPA directly by requiring consumers to verify their identity before they could opt out of the sale or sharing of their data. This is the first CPPA order to combine Delete Act and CCPA violations in one action, but nothing about the underlying claims should surprise anyone who's been tracking this agency. The CPPA has now brought more than a dozen enforcement actions for data broker registration failures across a variety of data broker models. What's useful here is a reminder of that range. LocateSmarter looks like the traditional data broker most people picture: skip tracing, people search data, and investigative records. Cybba doesn't. It's an audience segmentation, retargeting, and ad activation platform. The message is that the data broker definition under the Delete Act reaches well beyond companies that look like database vendors, and many types of ad tech companies may fall within that definition. If your business collects personal information about consumers you don't have a direct relationship with and sells that information to third parties, you're a data broker. Don't assume the data broker rules don't apply just because you don't look like a classic broker. The LocateSmarter opt-out issue is also worth flagging because we've seen this exact distinction before in the CPPA's Ford Motor action earlier this year. Under the CCPA, businesses can require identity verification for rights like delete, correct, or no. They cannot require verification for opt-out requests. A business can ask for information necessary to complete the opt-out, but if you can honor the request without additional information, it has to do so. It's an easy mistake to make if you're building one uniform process for all consumer rights requests, but opt-out has to operate differently, with fewer barriers than rights that require a verifiable consumer request. The takeaway: if opt-out requests run through the same verification workflow as your delete or correct requests, you may need to make some adjustments. Moving on to Colorado. Colorado has released draft rules implementing its reenacted Automated Decision-Making Technology Act and its new Chatbot Safety Act, both operative January 1st, 2027. The rules cover developers and deployers of automated tools used for consequential decisions, things like employment, housing, financial and lending services, and healthcare, plus a separate set of obligations for companies operating conversational AI services. But I'm going to focus on the Automated Decision-Making Technology, or ADMT, side of the rules. Colorado's approach to ADMT tracks the general shape of California's regulations, with pre-use notice, consumer opt-out rights, and a right to meaningful human review after an adverse decision. But Colorado goes further on mechanics. The right to meaningful human review is already required by the underlying statute, requiring a reviewer with authority to override the decision, not just rubber stamp it. The draft rules build on that by requiring that the reviewer be shielded from retaliation and insulated from management pressure, and by trading a full reversal as evidence the review was genuine. California requires a similarly empowered reviewer, but doesn't prescribe that level of independence or process detail. The rules also create something new: a midstream developer category for companies that build ADMT into their own product before passing it further down the supply chain. That's not a term the statute itself defines. It's the Consumer Protection Division's way of making sure documentation actually flows through multi-party supply chains, rather than stopping at the first handoff. Colorado's approach here is also notably more developed than what most other states with profiling rights currently require. Several limit their protections to opt-out rights triggered only by fully automated decisions, without anything like a full human review mechanism attached. The bottom line: if your ADMT compliance program is built around California's rules, other state profiling requirements, or even the underlying Colorado statute, don't assume it will map cleanly if these draft Colorado rules are adopted. The human review mechanics are a foreseeable extension of what the statute already requires, but the specificity is new, and the midstream developer tier means multi-party supply chains may need a documentation plan that didn't exist before. That's this week. 2 data broker fines that remind us of the range of companies that qualify as data brokers, and Colorado's draft rules raising the bar on human review of automated decisions. You can find more on both stories in this week's newsletter, A Little Privacy Please. I'm Julie Rubash. Thanks for joining me, and I'll see you next week. Until then, go enjoy a little privacy, please.